I think it's gonna start. Where's Shivadeep?
So, Neha,
Yes.
so I think the way it's going
I
is
think the
Mr.
audio
Mitra
is
on.
on. I think the audio is on for everyone.
Just hold on. I muted all the participants now. So Suhana, now you can speak. Tell me.
Yeah, so I'm saying that if Mr. Mitra is on, we could have discussed with him. So basically, I think Supratim is speaking first. And Shupro, you're taking your question answer first, right? And then Arindam and I are speaking.
Right, right. Yes.
Yeah.
So firstly, I'm going to introduce CD sir and three of you, and then I will going to ask CD sir to introduce all of you, and then you people can start your session, right? Hello.
You need to.
Yeah,
Hello.
Arindam, tell me.
Can you hear
Yeah.
me?
Yeah, yeah.
I'm saying you can just introduce. You can just introduce CDM, and then he can take over. Yeah,
Acha.
and just the general top and CDM, and then he can take over. He can introduce the three of us.
ठीक है,
I
done,
mean, no
done,
point
done.
in double introduction.
Okay, fine. So we will start the session sharp 5 or 5. Okay. मैंने कर दिया सर, आप चेक। Hi sir. Hi Shubhadev.
Hi.
Siri sir, we are unable to hear you.
Can you hear me now?
Yeah.
Okay, so I think the
Yes, can you? Are we
okay,
all
so
audible?
Neha, we confirm the broadcast is not on because we got a message. We
Yeah.
got to
Broadcast
know
is on.
so
Can
the order
participants-
you mentioned is Shupratim, then Arindam, and finally Suhana. Am I right?
That's right.
That's right.
Okay,
So,
so this is what I'm suggesting. I'll just do a very short 30-second, 1-minute kickoff, and then I'll introduce Shupratim first, and you can then take the screen and move ahead. At that time, rest of us can both unmute our videos and unmute our, I mean, just at the first saying hi for 30 seconds, maybe all of us can be there, and then we can all unmute our video, unmute our sound, except Shupratim, who's you need to keep your sound on. At the end of the presentation, then I'll just introduce Arindam, and then you carry on with your unmuted audio, and at the end comes Shohana. And at the end, when the Q&A starts, then at that point of time, if possible, if the bandwidth allows, I think it's a good idea if you're visible along being with audible, right? Because then people get a sense of you giving the answer properly, right? Is that okay? But if there's a bandwidth problem, worst case, you can unmute your video. Worst case.
Sure. Right. I think two things. One is, I think this sounds like a good plan. I think Suhana would be controlling the slides for all of us. That's one.
Okay.
And
That
the
is
second,
up to you guys. I mean, I'm
yeah,
leaving it to you.
yeah.
I
And
am pretty much going to play a whatever absentee landlord role, okay? Except just introducing you guys and coming in at the end for the last whatever 10-15 minutes of Q&A and maybe moderating a bit of that, right?
okay.
And Neha, just a request. Sorry, Shupratim, I just cut you. I request. Don't mute us or let us handle our webcam and our mute buttons because that's
Yeah, we
easier.
will do our own muting. Yeah, that sounds good. Because in case somebody needs to chip in or whatever, and that freedom you should have. I get it. I agree. Fair enough.
Sure.
And my
let's keep
Q&A,
our
I would
WhatsApp
like
group
to.
handy. Let's keep our WhatsApp group handy if we need to,
Yeah.
write
Keep your
anything to each
WhatsApp
other.
group handy so we can have a parallel conversation in case we need to alert each other. You know,
Yeah.
Somebody's forgotten to mute and all that. You can put it on the WhatsApp group. Yeah, that's a good idea.
One last thing is my Q&A. I will take right after my speaking slot because I'll have to log off.
Okay.
Yeah.
So I'll mention that. Thanks for alerting me. I'll mention that. Yeah.
Thank you.
Good. Okay. So Neha, we are all. I think we'll keep our videos on just to kind of say hi to everybody, and then we can put it off. So whenever you're ready, you tell us to. Are you live now? No, not yet.
Yeah. I'm live.
Okay. So it's 5:01. Should we start now or what?
We will start after 5 minutes.
Okay.
Just
So then
for 5 minutes,
let's do
join.
one thing. Neha, you unmute us, and I mean, we'll keep our camera and this thing all on, and you start the session. Hand it over to me, and I then introduce and hand it over to everyone else. Okay. So you just do the muting for all of us right now.
Sure.
After that, leave it to Buzz.
Done. So I guess now we can start the session. So hello everyone. This is Neha Agarwal from TiE Kolkata, and we are here for our next session called Impact on Data Privacy, Deal Marketing and Navigating Contractual Issues Amid COVID-19 Crisis. And now I'm welcoming Mr. C.D. Mitra, Mr. Chandradeep Mitra. He is our executive committee member and uh, our charter member as well. So please welcome C.D. sir. The stage is yours.
Hi everyone.
Hi.
Am I audible? I think I'm visible. Yeah, good. Okay, so thanks, Neha. I'm going to take it from here, and my job is to be largely both invisible and inaudible, except to come in to do two things. One is it promises to be a very interesting and important session for all of us here at TiE, because with all the unprecedented stuff that is happening thanks to COVID, one of the things that will have short, medium, and long-term repercussions are all the kind of legal implications, specifically, contractual issues, deal making, and data privacy. So we have three partners, three eminent people, all from Khaitan and Company, who have very kindly agreed to be part of that. So I want to thank each one of them. Supratim, Arindam, and Suhana, hi. Thank you for being here with us, and we really appreciate you taking time off. I know you've also been doing sessions elsewhere, but for us here in TiE, this session is going to be really important, because we are a lot of people here are owners of companies. Some of them are startups, and I'm sure all of us are going to face a very unique legal challenges, and are already facing and will face soon. So it's good to be prepared, and no one better than all three of you coming together to share us. So I'm going to, the way we're going to do the session is I'm going to introduce each one of them in very briefly in about a minute, and also briefly mention the topic that they're going to cover, and then I'm going to hand it over to them. I'm going to mute myself, both visual and audio, and when that session gets over, the first session is going to be done by Supratim. Unfortunately, he has an urgent call, so only for his section, what we will do is we will take about maybe 5-10 minutes of Q&A, if there are any. Am I right, Supratim?
Yes, that's right. Thank you.
Yeah. So Supratim will do his bit of the Q&A, and then he will have to unfortunately leave the session, but he will finish his section and even answer all the questions and all, and then he will have to go off for another urgent whatever video call or meeting with the client. And Arindam and Suhana will stay on, and the next speaker is going to be Arindam. I'm going to introduce him. He's going to mention his topic. He's going to talk about that, and finally it's going to be Suhana. And the last session is going to be Q&A, where Arindam and Suhana are going to be able to take all your questions the best they can. Yeah, and we are aiming to have a session. I think the total presentation that you three have is going to be about close to an hour and a half. Am I right?
Yes, approximately.
Approximately, and then another, depending on how many questions there are, maybe 15-20 minutes of Q&A is what we are planning. Is that right, Neha? That's what we plan to do. Okay.
Yes.
Okay. So with those words, let me start off again, thanking all the speakers, the partners from Khaitan, and of course, thanking the participants of the webinar. Right now, I think we are attending a lot of webinars, partly out of choice and compulsion, partly because there are not that many things you can do, but it's also a great opportunity and great time to kind of catch up on learning, but more importantly also know how to navigate different aspects of the new situation as it keeps evolving, right? So today's session is really all about legal, and the first speaker we have is Supratim Chakraborty. He's a partner in the corporate and commercial practice group of Khaitan. He also specializes in IT and data privacy and protection laws In fact, that's what he's going to mainly focus on in this talk. In fact, he's one of the few people in the country whom the Ministry of Electronics and Information Technology had separately written for additional comments when the Personal Data Protection Bill, upcoming one, was being framed. He holds a GDPR FA certification and a DPO certification. Is a member of ASSOCHAM's National Council for FinTech, Digital Assets and Blockchain Technology. And what Supratim is going to talk about is mainly the whole issue of data privacy and data protection issues. There are 2 or 3 kinds of issues which are coming up, and he's going to expand on them. One, of course, is that now that we are forced to suddenly, at very short notice, work from home and using different platforms, how does the whole data protection work out, and what are the legal safeguards or not for that? Which is within the bounds of law and stuff like that. And the other thing is, of course, thanks to COVID, a lot of governments and other organizations, social media organizations have, they have much greater scrutiny on activities of individuals and organizations. Now, where does it, overlap with data protection issues, and how do individuals and organizations navigate all that? I think these are some of the things, and I think it's a very fascinating topic. I'm personally looking forward to that. So with those words, I'm handing it over to Supratim. Supratim, over to you, and glad to have you here.
Thank you so much. Very kind of you, Chandradeep. I think when Chandradeep and we were speaking about, and all of us were talking about this particular session, we first thought that there are 2 things which are absolutely a taboo and antagonizing people these days, many of us, in fact. One is webinar and the other one is COVID, and in that same order. So we thought that though we will talk in the pretext of COVID-19, and we will talk in a webinar, but the takeaways we will provide will be long lasting, and this would be useful for you for for very long time. After this lockdown is over and after we go back, you'll realize that these takeaways, if you have taken proper note of what we are stating, could be helpful, perhaps lifelong. So with that, I will quickly jump on to the session. Next slide, please. So, all of us are in organizations which are, handling different kinds of data. So if you look at the slide in front of you, this is talking about the general kinds of data that is, that is relevant or that we are handling, whatever be the size of the organization, small, big, it does not matter. And therefore, it's very important to take cognizance of how to handle them. So the largest one, if you see on the right hand side, is the confidential data, where basically this would consist of your client's confidential data, your know-how, so on and so forth. How do you protect it? Largely through contractual measures, through tech measures. You would have some intellectual property related safeguards, so on and so forth. So in the present day context, for example, you have given a lot of your information, confidential information, to your employees who are working from home. Have you gone back and checked the agreements that you have with your clients or customers who have given you this data? Probably you should, because if you are not following the security protocols or confidentiality measures the way they are written in that agreement, it's a good time perhaps to ask for a waiver, at least send a notice saying that this is how we are managing things, so at least you're insulated, and in a bad day you can project this as a good defense. That's one. On the left hand side, if you see, is the large bucket called personal data. Now this is any personal data. For example, right before the lockdown, in organizations we were collecting information such as travel history. So that is personal information. How do you really protect that? Consent is king. Remember, if you are handling this kind of data, you need to take appropriate consent. And in the center of the slide, if you see, there is a bucket called sensitive personal data or information. Now, what are these? This could be medical information, temperature related information which we had collected from our employees right before the lockdown, and possibly after we open up also we will continue to collect all this information. And how do you really protect this information? It is not only consent. Consent is just one pillar of this. You also have some other reasonable security practices and procedures which you have to follow in order to safeguard the information. So that is in short what is the kind of types of data and how to protect them. And the reason we are talking about it today is because, unfortunately, our laws, whatever we have today, does not have a special avenue for a situation like COVID or a pandemic, and therefore we have to follow it. Also, the regulations or the notifications, whatever are coming out right now, they are not providing a clear leeway that you need not follow these regulations and you are otherwise good to go, even without following. So therefore, we are in a very tricky situation. But I'm quite positive actually, and I believe that even in this situation, it is quite possible for you to follow almost all these requirements in an inexpensive manner, and I'll show you how. So you remain within the bounds of law in an inexpensive manner. At the same time, you are you are following whatever is required to be done. So next slide, please. So in how I would like to bifurcate this particular discussion is, let's look at this situation by thinking about two stages. Okay, stage one is the initial outbreak, when this COVID-19 outbreak happened and measures were taken largely in a I would say knee-jerk reaction manner. What did we do? We took thermal scanning was done, temperature was recorded, and possibly it will be continued to be taken. And therefore, it's important, as I told you, to take note of these measures. We obtained declarations of medical conditions, collected travel history and associated details. We notified our relevant employees and of suspected and positive cases, perhaps. Remember, India is a very peculiar society. Okay, so all this information that we are talking about, it is not only important to safeguard from a legal perspective, but also because of the societal need that is there. We are, to my mind, we are not savvy or mature enough to handle this kind of information. You could really scar an employee for life if some of this information goes out, not only in your organization but wherever the poor chap goes in future. So it's a moral duty, I would say, to protect this information as safely as possible within the bounds of law. Now, having said that, let me tell you. So I just recollected, one of our clients came running to us when they had put up a thermal imaging camera suddenly when the outbreak happened, and some of their employees raised a hue and cry. So we guided them through, regarding the notice to be put up, the consent to be obtained, etc. Unfortunately, the Indian context, we all get a lot mixed up in our head regarding notice and consent. These are two completely separate aspects. How do you put up a notice? What are the elements of notice? When you take consent, how should you take the consent? And believe me, the law does not put a lot of rigor on you regarding consent. Any mode of electronic communication is permitted to take consent. So you can simply send an email and the guy says, I accept, I agree. That should be good enough. Okay, as far as the IT Act is concerned. Apart from that, of course, there are reasonable security practices and procedures which you could follow. There are disclosure and transfer related restrictions, and there is data minimization, purging, or deletion, which should be done. Uh, you know, um, which should be done at the end of this entire fiasco. Is my audio proper, or should I switch off the videos for a better audio?
It's fine.
You're
It's
absolutely fine.
Okay, perfect. Next slide, please. So, like I was speaking, that in this stage of if we have to really deep dive into this particular stage and understand what are the legal requirements, we need to understand what do we have as a law in the country. The idea is not to throw a book at you, but just to make you aware that there are certain laws which are spread all across several legislations. We will pick up the most relevant ones for you, and sort of tell you that how easily you can be compliant. So we do not have any exclusive legislation. Right to privacy, of course, has become a fundamental right. On a sector neutral basis, it is the Information Technology Act, and this long name that you see in front of you, which is called the Privacy Rules or SPDI rules. They kind of guide you through handling of sensitive data. What, again, sensitive data like financial information, health information, medical history, all of that you've been probably collecting from your employees and maybe customers as well. Sectoral regulators also play a large role. For example, Reserve Bank of India giving its diktat to banks and NBFCs, IRDI giving its diktat to insurance players, so on and so. So they also have some kind of a norm which is set out. Apart from that, there are other old archaic legislations which are there, like Indian Penal Code, Consumer Protection Act also plays some role. You will have Indian Contract Act, so on and so forth. So all of this taken together is really our patchwork of laws. Next slide, please. So when we talk about the so when we talk about these provisions of the Information Technology Act, I would like to speak to you about only two important provisions. One is Section 43A, which deals with sensitive personal data. I will show you what are sensitive personal data. So if you're handling sensitive personal data, you need to have reasonable security practices and procedures. And otherwise, if there is a wrongful loss or wrongful gain caused to anyone, then damages would be payable by way of compensation. Now look at this amazing aspect, okay? When the European Union law, which is the General Data Protection Regulation, came into effect, any organization which had any kind of touch point with EU suddenly sat up to the situation. Why? Because the penalty is 20 million euro or 4% of annual global turnover, whichever is higher. And we always had this provision in our law, which is uncapped. But perhaps because of inadequate or improper implementation, that not many of us are aware of it. Next slide, please. So when we talk about Section 43A and sensitive personal data or information, we need to understand that what are really the elements of what is this reasonable security practice and procedure that one is asking us to follow. Now in good times, I would not say fall back on this interpretation, but because the times are tough and we have to have some sort of interpretation which is helpful, and therefore I'm pointing out to you one aspect which is mentioned in this particular this section itself, which is on reasonable security practices and procedures. Are those practices and procedures designed to protect such information from unauthorized access, damage, use, modification, disclosure, or impairment, as may be specified in an agreement between the parties or as may be specified in any law. Look at this. So basically, you and I can decide what do we do with your sensitive data, or we may follow the law. Now, this is not a correct interpretation. I would say this is just for taking aid in this exigency. That at least have proper consent or proper sign off from the individual whose data you are handling. And therefore, I go back to my earlier point, where I stated that consent is king. Ensure that you have appropriate, clear, adequate consent from those individuals whose data you are handling. Next slide, please. So now we will discuss about what is sensitive data and what is really sensitive personal data as per today's law. Very important slide for all of you because some of these provisions are not defined, etc. So what is sensitive data? It is password, biometric, sexual orientation, physical, physiological, or mental health condition, medical records or history, and financial information such as bank account, debit card, credit card, or other payment instrument details. But mind you, before it becomes a sensitive data, it has to be a personal information first. So in case you are able to completely anonymize any information, okay, for research and development, perhaps you would need some. So then that goes outside the purview of this law. So globally, I'm telling you, whether it is our law, whether it is our future law, whether it is the gold standard of Europe, the European GDPR, if it is anonymized data, it is outside the purview of the privacy laws. Next slide, please. Now, if we are handling sensitive personal data or information, what are the safeguards that we need to have? And these are the safeguards. You need to have reasonable security practices and procedures, disclosure related norms are there, consent, collection, transfer related provisions. You need to have a privacy policy appropriately worded. Again, these days, I think the policy aspect you need to be very, very careful about. We see many organizations where people are working from home, but they do not have a work from home policy or a teleworking policy. Some of them are letting their people use their own devices, but there is no bring your own device policy. So in a bad day, believe me, this is what will come handy. And it is not very difficult to put it all in an email and just send across and take a I accept or I agree. These are simple measures which you just need to sort of put in place and get actioned. Grievance officer needs to be appointed, but again, it is not an earth-shattering requirement. There is no benchmark, there is no threshold set that this guy has to be, say, an engineer or a DPO or whatever. it is any person who can attend to a grievance by a sensitive personal data provider. Next slide, please. So we have seen this actually, a lot of organization gets flustered that, oh my God, we have to have a, grievance officer. So collection of information, when you are collecting sensitive data, just be mindful that, it should be collected only if it is necessary. So when you're collecting all this temperature, medical information, etc., just ensure that it is necessary and it is only used for the purpose for which it is collected. The information provider should know. So this thermal imaging that you are doing, the person should know that the information is being collected, the purpose of collection, the intended recipients, the name and address of the agency that is collecting and retaining the information. Sensitive data should not be retained for longer than required. I told you this. And information providers should be allowed or given an opportunity to review and amend the information if it is required. So next slide, please. Apart from this, we will also tell you some of the other nuances of disclosure and transfer which you should be mindful of. So disclosure. So disclosure should be as per the agreement with the information provider and obtain prior permission from the provider. Of course, government agencies who are mandated by law have a leeway. And as far as consent is concerned, ensure that when you at least should take a consent for prior consent from the provider of information regarding the purpose of usage of this information. And if you intend to transfer this information to, say, your service provider at the back end who will process it for you, etc., all that is perfectly fine. You can send it within the country, outside the country, it does not matter, provided the two things are taken care of. One is that the recipient is also following the same requirements as you are following under the law, which I already spoke about, and there is a consent which has been obtained from the provider of information. Next slide, please. The next slide will show you that the two areas where we see major pitfalls by organizations, whether it is small, big, it does not matter. Privacy policy, how it is to be crafted, what are the things to be written? These are the must-haves if you're having sensitive data. It should set out the type of information that you're collecting, the purpose of collection of information, the security practices and procedures that you're following, and the disclosure policy. You need to have a grievance officer. As you can see, as I told you, name and contact details of the grievance officer needs to be published on your website, and this officer needs to redress the grievance within 1 month. That's it. These are all extremely simple, I think, and can be sort of rolled out and at any given point in time. Next slide, please. So apart from these provisions, it is also important to look at another section of the Information Technology Act, which is section 72A, which deals with personal information. Now, personal information is wider than sensitive data, sensitive personal information. So therefore, you need to be more cautious. If you've obtained this for, say, providing of any service, etc., then you should only use it as per the consent. Again, consent is king, as I was telling you. So any disclosure which is made without the consent or in breach of a lawful contract is punishable with imprisonment for up to 3 years or with fine up to 5 lakh rupees or both. Next slide, please. So this, I think, is largely the first stage, okay, and probably things that we should be keeping in mind when we are going ahead. Now, before I jump on to the second stage, I would pause here for a few seconds and I would like to see if there are any questions.
Okay, so if there are any questions relevant.
Hi everyone, I have unmuted all the participants. If participants have any queries, any questions, please ask. Anybody has any questions?
जहाँ पर आप वर्किंग करते हैं
Is they don't have any questions, we can start our. You can further start your session. Supratim.
Thank you, Neha. I think anyone, Chandradeep, you wanted to say something, or should I continue?
Yeah, no,
Yeah,
nobody. Yeah, you can start.
Neha, I'm not sure you unmuted everyone. At least some of us, the panelists, were not muted. So, okay, Supratim, I have a couple of questions,
Okay.
if I may, maybe
Yes,
on
please.
behalf of others or maybe on behalf of myself. One is this, grievance officer. Is it somebody who needs to be a person within the company with a certain kind of background or qualification, or is it like an ombudsman who's outside the company? Who is this person?
Yeah, so thankfully, Chandradeep, there is no such requirement. It can be a person within your organization, outside your organization, and there are no technical qualifications which have been provided. However, what we advise generally clients is it is advisable that you have someone internal, A, B, someone possibly from the tech or legal background who would be able to respond to the query. That's about it.
So ideally, it should be a person who knows both technology and law, which is a slightly rarer combination, right?
I didn't want to put it that way, but yes, it's a rare combination, but you can have either of them, or possibly someone who's at at a senior level who would be able to appreciate the ask or the grievance of the data provider and would be able to provide a timely response.
And the purpose of the grievance officer is to basically, in case there is a legal issue, is to prove that the company did due diligence in terms of responding to the complainant. Is that so?
Sorry, I didn't get. Can you repeat the question, please?
Yeah. So the purpose of having a grievance officer is first and foremost, in case there is a genuine issue, to address it, and secondly, in case things go out of hand and go into a court of law, is to prove that the company did its due diligence, both to have a
Absolutely.
mechanism and then to address a problem, and therefore reduce the liability of the company. Am I right?
Absolutely, brilliant point. I think that is one of the touchstones. I'm telling you, going forward, this is also becoming more important, because demonstrating compliance is the new fad. I would say the new requirement. Apart from whatever you are supposed to do, you have to demonstrate that you have been doing it correctly and appropriately. For example, these training sessions, how important these are, you won't believe that all these GDPR, the general data protection related breach notifications that have to be provided, that has got line items which state that have the relevant people been trained, when were they last trained in the organization, so on and so forth. So you can imagine the importance of these aspects of demonstrating compliance, and you're right.
Okay. The next question, and then I'm going to let you move ahead if there are no other questions from anybody else, is this consent. You said notice and consent are not the same, and you said consent just over mail, etc., may not be. Did I get it right? May not be legally completely valid.
No,
So is
that
there
is in fact as per
a
the
way of
IT
getting
Act.
consent, which is correct?
As per the IT Act and the rules, in fact, they're saying that any mode of electronic communication is fine for this particular consent on sensitive data. So it's the other way around. Actually, they are giving you the leeway to take it in any mode of communication, electronic communication.
So basically, if the management or the HR or whoever of a company sends a mail, because right now suddenly companies have shifted to work from home and all of that, or they are doing thermal imaging when people are coming back to office, coming back to factories, whatever. And
Yeah.
all you need to do is send a mail with those clauses, and just saying that reply back with a yes, I understand, I've read it and accept it, and that's good enough to protect.
That is good enough.
Okay, great. And is there any standard format of course, I know it will vary from company to company and what you're recording, but are there some standard formats of what that consent form should be like?
No, there is no standard prescribed form, but as I told you, that's why for the benefit of everyone, I have jotted down the important elements that should be there. Now, how you craft that element is up to you. Our suggestion is that keep it extremely simple, so that even a layman could understand without too much of a legal ease. You should try and put this in say short bullet points and make them agree.
Good. Nice to hear a lawyer saying use layman English. Thank you. Okay. now, unless there are any other questions, I think you should move on to the next section.
Great. I think I'll move on, and then possibly at the end, I will request everyone to, I'll request for unmuting everyone, and then maybe we can see if there is any questions. So with that, I'll get on with the next part of this presentation. I hope my audibility is still fine.
You're absolutely fine. You're both audible and visible. Don't worry.
Great, thank you. So stage 2 is what we are in right now. Okay, work from home. So we are again facing new challenges. We were never prepared for this. For example, the owners of Zoom, after this whole fiasco blew up, they came and said that, we are sorry, but we never realized that the whole world would be on our platform one day, which is a true fact, really, right? So what are the challenges? The first one, if you see, work from home with access to organization sensitive data. I remember again, another of our client came running to us saying that till date, we had this sensitive information only given to our employees at office, and we were not handing this over for use at home. But now we have to upload all of this in a cloud so that employees are able to use it from their remote locations. What should we do? So we told them, we charted out a plan for them, but most importantly, what we told them is, remember, all your physical guards are off today. There are only few logical guards that you can put remotely, you can access and keep some kind of a check. But today, the biggest human firewall that we have is the human firewall. So remind your employees of their obligations of non-disclosure, data protection, confidentiality. They will be your forces to protect you largely from many of these things that are happening these days on the privacy, data protection, and cybersecurity front. The second bucket, if you see, is the audio video calls from various platforms. You've been observing there is a flurry of platforms that we are on right now. And we are not sure that which is credible, non-credible. Suddenly a lot of things are being spoken about one particular platform, but the reality is that when you speak with the cybersecurity guys, they'll tell you these vulnerabilities exist less or more in almost every platform. Okay, so what you should do is check credibility, privacy policies, check the conference settings, the services that are available. Some of the settings we are not using, because of which we are making ourselves vulnerable. I'll go to the next slide and I'll show you, but before that, let me finish on this slide first. And before moving on from this particular point here, I must tell you that the thumb rule that I follow, at least, that if you are having a normal discussion, a conversation, or training of this nature over platforms, that's absolutely fine. But if there is something which is extremely price sensitive and something that is very dear to your heart, simply send an email the way you would like to send an office email. Ask the person to look at it, pick up the phone and speak on it. Okay, screen sharing there may not be a very good idea, and possibly you should desist from doing that. The next point is usage of personal devices and internet connection. As I told you, personal devices, many of us do not have those bring your own device policy or proper teleworking policy. Try and have those. Okay, internet connections, just ensure that you have a proper VPN, a router which is which is not having a default password since ever, things like those. And from an organizational perspective, you can always have remote monitoring for unusual activities, and ensure that you have access speed bumps. So not every information is available to everyone forever. So it should be something where you have a grip over the access, who is getting that access, for how long, and what all information they are getting. The last important thing which I would like to talk about here is e-contracting and usage of digital electronic signature. Believe me, there is a lot of confusion in the market as to what I can do digitally, what I cannot do. Because we are in a lockdown phase, of course, we are not able to move around, have ink signatures, and there's a lot of issue. But largely we can do a lot of things over, electronically. Electronic records, IT Act gives you that leeway. There is only a very small set of negative list of 5 things which you cannot do electronically, and they are negotiable instruments, power of attorney, trust deeds, wills, and contract for sale and purchase of property, moving property. So that's all that you cannot do. But minus that, you are free to do whatever you want. That's one. Now let's talk about this whole electronic signature and digital signature and fiasco. So forever in the IT Act, we had this concept of digital signature, and it was inscribed pretty properly. I think in the year 2009, when the IT Information Technology Act was getting amended through the Amendment Act of 2008, they thought of increasing the ambit of this e-signature to also bring in the concept of electronic signature. And that is where a lot of confusion happened, because the way it has been written all over, to my mind, gives some rise to some kind of a confusion. But I'll make it simple for you. So there are 2 sanctified buckets really. One is digital signature, the way we have always known it. Okay, the certifying authorities providing you those dongles, and it is asymmetric crypto system that they use. So that is always known to us. Electronic signature is basically all those security protocols which are otherwise mentioned for electronic signature in the IT Act, and what is mentioned in the second schedule of the IT Act, which is Aadhaar based e-sign. So these 2 are all fine. There is no problem. Now, apart from that, there are people in the market who started using several other, signatures. You will see DocuSign, Adobe Sign, etc., etc. Question is that you need to then deep dive and see, are they really fulfilling any of these? If they are not, then what goes wrong? What is incorrect there? Well, the presumption of law is not there in your favor. That's all that goes wrong there. Okay. Otherwise, everything is fine. So again, thumb rule: if it is a digital signature, if it is an Aadhaar based e-sign, you have the law on your side and you have a presumption in your favor. But on the other side, you may not get that kind of a protection. That's all. So with that, we go on to the next slide. So this particular slide, I am just talking about, some of the good to, sort of good things that you can think about. A simple, I don't think these are too difficult to follow in relation to any of these portals that we are going on for our video conferences, etc. It should be password enabled login and sharing of link with only the authorized people. You remember when the lockdown happened, suddenly these Zoom links were floating all over. It was in Facebook, it was on WhatsApp, and there was nothing required to be done. You just click there and you enter the chat room. That created a huge number of issues, and that is where perhaps largely where what we saw, the backlash that we saw, is perhaps largely because of that, apart from of course other security issues. Use of features like waiting room, where host has the authority to clear the entrance. Okay, you will first be waiting and then would be cleared one by one by the host. Disable features that let participants to join before the host. Control content sharing. Permission should be sought before sharing of information. Ensure consent for recording and storage of recording only with the authorized person, and ensure that participation is locked after all the authorized people have logged in. Next slide, please. So the next 2 slides that I'm going to talk about is just few tips for both the employers and the employees, so that in these times we know as thumb rules what we can do. Some best practices for organizations is work from home policy to be updated on website, and electronic consent from employees should be taken. Provide basic cybersecurity tips. We are dealing with human beings here, and they are too anxious today, clicking on anything and everything that is coming their way. Explain to them what is these phishing emails. Okay, earlier phishing emails were, I would say, not sophisticated, because they were talking about know who has COVID around you, increase your EMI, so on and so forth. Now it has become more sophisticated. It is stating, please enroll for this free webinar where XYZ very important people are speaking, and it is free. Okay, things like this. So you have to be very careful. Not using public Wi-Fi, downloading from untrusted applications. Deploy VPN, secure virtual desktop. Sensitize on breach reporting, how to do it, and if there is any unusual activity. Discourage local storage of critical or sensitive information and switch to secure solutions. Enable session timeout for remote operations and automatic screen lock feature. Review your NDA and other undertakings for protecting confidentiality of client. I spoke about this right at the beginning. And business information, and remind your employees of their obligations. Have a contingency plan in case key personnel falls sick. Have division of important roles and strategized in advance. And one more thing, before we start going back to our offices, you should remember that just like we had quarantined many people, it's important that before these office equipments, and some of them also moved, say, desktops to their employees' houses and all that goes back into your office network and office premises, you need to carry out a proper sanitization. And the sanitization is not only physical sanitization, it is also electronic sanitization. So to check that nothing untoward is going back into your system. Next slide, please. So the next best practices is for employees. Really, I think it's a joint effort. Both of us need to come and see how best we can tackle this pandemic. Ensure that compliance with work from home policy, teleworking policy, IT policy, etc. Frequently reset your password. Use password managers, two-factor authentication. Refrain from using personal emails or unauthorized services for sharing of office information. It's a thumb rule. If you do not do it at office, you do not do it at home. Simple. Ensure that all security patches are up to date, antivirus is updated. Disable remember password function. Call the sender of the message to verify if you have received any suspicious email, especially payment related emails. Pick up the phone and speak to the guy. Did you send this email? Have you asked me to make a payment? Double check that. Avoid clicking on unreliable, unverified links, email attachments to protect against phishing and other cyber attacks, and promptly report any cybersecurity instance, data breach, or unusual activity. So with that, I will close my presentation and I'm open now for any questions. Thank you.
Okay, Neha, maybe you can unmute everybody and also encourage people to, if they want to speak or put things on the chat box.
So I have unmuted all the attendees. If attendees have any questions, can please ask.
But now we are doing that we have tested negative of COVID-19 and the report has been submitted before we.
Yeah, hi Hitesh, please ask your question.
Yeah, so so
Hi, can you be a little louder? Sorry, I can't hear you.
Yeah, we
Please
couldn't hear the
speak
last
out,
bit.
we are able to hear you properly.
yeah, is it clear now?
Yes,
Yeah.
yes.
Yeah.
Now I can.
Yeah. So can we have some little bifurcation? What is personal data and what is confidential data?
No, so you mean to say what is personal data and what is sensitive personal data? Is that the distinction that you want to know?
Yeah, basically confidential data.
See, Suhana, can you go to that slide where we have set out the sensitive data? I'll tell you. So three things. Okay, one is that personal data is something where you directly or indirectly, with information available to you or likely to be available with you, you are able to identify the individual. That will be personal data. Then you will have within that bucket elements such as these: password, biometrics, sexual information, orientation, physical, physiological, mental health condition, medical records, financial information about an individual, which will be sensitive information. Now, if there is something which is over and beyond this, you could consider them and it is still very important for the organization, that could be considered to be confidential information. Now, if you go, can you just go to the first slide, Swana? If you look at it, the set and subset in front of you. Can you hear me clearly? Yeah. Now, if you Swana, if you could just go to that first slide with all the sets and subsets. Yeah. If you look at it, just see the right hand side bucket is confidential data. Now, this could be anything. This may or may not contain personal data. Okay. So personal data is very easy to kind of identify, I would say, by this parameter. Sensitive data even easier to find out, but confidential data is something that you need to identify. But in an organization, my presumption would be largely most other information, like how you are, operating a business, your know-how, etc. All those things would form part of your confidential data.
So personal data is basically a basic information of an any individual.
Yes. So like I told you, in a COVID situation, let's take
Okay.
the simplest example right now in front of us. So you took 2-3 things, right? One is you took the temperature of that guy, the medical history of that guy, and the travel history of that guy. Okay. Now the first two elements, temperature and medical history, become sensitive personal information. The third element is simple personal information, where through this, directly or indirectly, you are able to identify, okay, this person went to XYZ place and this is related and linked to him.
Okay. Okay.
Yeah.
So any information we collect through software application or an applications, whether this will be covered by this act?
It would be covered. It would be very much covered, provided just one touch point I am telling you, you should remember that you are able to identify the individual, the natural person, directly or indirectly. Okay. If by chance, if you are not able to identify the individual, then it does not fall within the purview of this.
So basically, you're saying
Okay,
if it's anonymized, then it's not personal or sensitive.
Perfect. Yes. But
okay,
the suggestion here is that do not anonymize in a form which can be easily, re-engineered. Because it is looked at very seriously by the law. In fact, the upcoming personal data protection bill had 8 counts of imprisonment set out, but there was a lot of hue and cry in the market, and people say that why should we have so many counts of imprisonment when the fines are already pretty high, and the upcoming law, mind you, has fines which are pretty stiff. So what it has gotten reduced now, but one count of imprisonment still remains, which is if you are trying to bring back anonymized data through de-anonymization. So that we have to be very careful about, that we use processes and protocols which are not able to get you back the information.
okay. And the definition of confidential data, anything that is not in the public domain, can it be called confidential or no?
Yes, it could be. So this definition of confidential data is not really spelled out in any law. And this largely depends on the organization, how they would like to create a ring fence around this. Yes, it could be. You could define it that way.
Okay. Are there any other questions, Neha?
Yeah.
Yeah, hi, good afternoon. My name is Kinshuk.
I can't see the chat box. Are there any questions on the chat box, Neha?
Yes. Yeah. Good afternoon.
Yes, hi, good afternoon.
Yeah, hi, my name is Kinshuk. I just, asked a question in the chat box. So firstly, thank you, TiE and Mr. Chakraborty, for a wonderful session. This has been great insight to me, both from the work from home perspective in particular. We are a recruitment consulting firm, and at this point in time, many of our recruiters are working from home. Traditionally,
Right.
most of these people were working from office, which is monitored and controlled in a safe and secure environment, where we are able to understand the kind of pitches our recruiters are doing to the candidates or potential candidates. Now, given a scenario that this work from home will continue for quite some time, and that's how we fathom it, is how do we ensure that a wrong a, an issue with compliance is not being done by a recruiter with a potential candidate. For example, a recruiter may always share something with a potential candidate which is not correct. That is a possibility. I'm not saying that will happen, but there is a possibility. There might be misinformation that might take place. Now, at a home environment, we are unable to control this. We do not have CCTV. We do not have a supervisor sitting beside him or her. Okay. Now, can we enforce call recording? I don't know how. What would be your suggestion in terms of how we enforce one-to-one interaction over phone as a recruiter operates from home.
Right.
Thank you.
I think, see, several businesses are grappling with this kind of issues, and unfortunately, it is every business who have to come out with a pragmatic yet safe measure, I would say. That is what we have been observing people are doing. But what you can do probably are 2-3 things. One is that if this individual who's working for you, I'm assuming that when you're talking about these recruiter, it is the individual who's working for you as your employee, right? That's what you were alluding to.
Yes, could be an employee, could be an associate, whatever.
Associate or whatever. So my point is, at this hour, what I recommend is over communicating is better than under communicating. Okay, you can always have those additional measures like having a parallel call or call recording and all of those, basically, where you are able to, of course, the call recording should be after the person is aware that this is getting recorded and all that. Both sides should be aware. So that is all fine. But I'm saying that what we have seen working very well is that a constant communication at this hour from the organization about the do's and don'ts. And don't write long emails, okay? Simple advisories with ticks and crosses that these are things to be done, these are things not to be done. Even after that, there is a possibility that things can go wrong, right? But this can go wrong even in an office environment. I would not say that this, of course, the probability perhaps goes up because there is a lack or little supervision over the person, but the supervision should be built in through a different methodology, and that is a practical methodology of constantly sensitizing that guy. Don't antagonize him, but basically just keep telling him nicely, give examples of things where people have gone wrong, and possibly that works pretty well. We have seen several times where if an issue which has been committed by one person is made known on a no names basis, that one of our people did this, or in similar industry someone has done this incorrectly, and that has kind of aided to curb the issue.
Okay. Okay. Thank you so much. Thank you. One more, just to build up on this, you mentioned, call recording has to be aware from both the sides. Okay. Can you highlight a little more on this? And let's say, for example, somebody records a call without knowing the other party. Okay. Is there a legal implication on this?
There could be legal implications for this, and therefore it is important, to make the parties aware that this is getting recorded for whatever purpose. And purpose, I told you how important purpose is. So purpose limitation is a very big thing in any kind of personal communication, personal information. So do make the person aware and then go ahead and do it. You're relatively insulated.
Right. Thank you so much. Thank you. Thank you. Thank you.
Okay. If there are no other questions, and I know Shupratim will have to leave for a meeting.
I think Mr. Shankha Shubra has something to ask. He has raised his hand. Yeah, hi,
Yeah,
Mr. Kundu.
Yeah, please allow Mr. Kundu to ask. Or at least.
Can you hear me, Mr. Kundu?
Hello.
Yeah, hi. Please ask
Yeah,
your question.
am I audible?
Yes,
Yeah,
yes.
you are. Go ahead.
Yeah. I'm Shankho. My question is that as far as digital signature and Aadhaar-based e-signature is concerned, how to go about contracts and agreements which are being signed virtually? I mean, as in, say, if an agreement is exchanged over emails between two parties, and they want to put their signatures on so that the agreement or contract takes a final shape, then what kind of signature is to be used and how it is to be done?
So I told you, if you want to be absolutely certain, and if you're trying to follow an absolutely insulated process, then there are two avenues which are available to you. One is digital signature, the way it is given in the IT Act, and the Aadhaar-based e-sign, which is also stipulated in the IT Act. Okay. Apart from that, if you are utilizing anything else, then the problem would be that the presumption, the natural presumption of law that is there, would not be in your favor.
Okay, so in that case, the agreements might be, if before the court of law, it might be turned invalid, that particular agreement.
It could be. So therefore, you'll
Okay.
have to, follow a lot of processes and
All
protocols to
right.
see through that how it is still valid.
Okay. Thank you. Thanks.
Okay. So I'm assuming there are no other questions, and I do know we have two more very interesting sessions. And I do know that Supratim has to go for a very important meeting. So with everyone's permission, I'm going to thank Supratim profusely from all of us. This was a very, very interesting session. And we look forward to having you with us at TiE again. And chances are individually, some of us may contact you separately. So please be there to help us and guide us in future. And stay safe. All the best, and all the best for your work ahead. Thank you.
Thank you very much. And before I sign off, big round of thanks to all of you, to TiE, to everyone in the organizing team, to Chandradeep. I think you guys were fabulous. I really enjoyed speaking at the session, and hopefully this association will continue. Thank you, and I'll sign.
Thank you so much. Thank you. Bye.
Great. Thank you. I'm now going to introduce the next speaker, which is Arindam. And I've interacted and met Arindam before. Part of the reason is that he's pretty active, and I think some of you may have also met or interacted with him because he's pretty active in the startup ecosystem. So Arindam again, Arindam Sharkar, that's his full name. He's a partner again in the corporate and commercial practice group of Kaitan and Company. He has over 15 years experience, and his forte lies in venture capital, private equity investments, cross-border M&As, business transfers, JVs, foreign investments. He's been advising MNCs, entry strategies, M&As, and financial transactions. And he also spearheads a startup practice in Kolkata for Kaitan, and actively involved with startups, including Calcutta Angels, TiE, Kolkata, Venture Catalyst, Neotech Hub, etc. He's a member of ICC Next, the core committee of ICC for catalyzing startups, and he's an independent director on the board of various reputed companies. And what Arindam is going to talk about with us today is about various steps involved in transactions, be it mergers, acquisitions, or investment, minority or otherwise, the kind of due diligence, drafting and negotiations of agreements, getting government approvals. We all know now there is this whole thing about Chinese investment, all of that. Maybe he'll touch upon that. And basically getting your house in order as far as financial contracts, investments, etc. concerned, financial or legal, and also how the whole pandemic has affected ongoing transactions, what are currently being processed or already underway, right? With those words, I'm going to request Neha to unmute Arindam's video screen and also make him audible.
Yeah. Arindam, please switch on your webcam.
Hello.
Yeah.
Okay.
Hello.
Perfect.
Hello.
So the person you see on screen has been using time to grow a beard, so he looks a little different, but he's the same person. I can vouch for it. Okay, go ahead.
Thank you so much, Chandradeep. I'm sorry, I probably have to keep my video switched off because I'm facing some bandwidth issues.
Okay, no problem.
So my apologies for the same.
We got a glimpse of you. We like your new beard, so go ahead.
Okay, and thank you everyone for being with us today for this webinar. In this webinar, what we are exploring is the impact on the deal making and navigating contractual issues and data privacy. You've already heard from my partner Supratim Chakraborty, particularly in light of the COVID-19 crisis. COVID-19 continues to create an evolving list of challenges. India is among the most affected economies. This webinar is our attempt to help you understand the current situation and some of its repercussions on some of the ongoing deals that we are doing. Besides its effect on human lives, COVID-19 is slowing down the economy, and companies need to take proactive steps to combat its negative effects. As frustrating as it may be, we need to review our framework. Major countries have already adjusted their growth focus on account of the blow dealt by the pandemic, and this blow will be felt for a long time. It's important for us to take stock of the situation before moving forward. In this particular section of the webinar, I'll take you through some of the difficulties that we have been facing on the legal side as far as transactional work is concerned. So let us look at the slide which is in front of us. The current scenario seems to be pretty gloomy. The International Monetary Fund, Federal Reserve, as well as our very own Reserve Bank of India has issued statements acknowledging that recession is here or probably is imminent. As with the ongoing travel adversaries, all non-essential transactions are also taking a hit. Through the next few slides, we'll explore how some of the ongoing transactions have had to take a hit and alter the course to cater to the current situation. Can we move on to the next slide, please? Thanks. Now, if you see the slide, the first step of any transaction, particularly from a buyer's perspective or an investor's perspective, is a due diligence exercise. Now, as far as a due diligence exercise is concerned, we have had to adjust and realign on how to conduct diligences during these times. Typically, we would visit a site, or we would go to a data room and review documents, or maybe not everybody provides for a virtual data room where they upload all the documents, but that's what we are insisting our clients to do now, particularly in this kind of a situation. There are many clients who have actually taken a step back with respect to the ongoing deals. Some are even considering dropping deals. But our advice to our clients have been to assess the situation. COVID-19 and its repercussions should not be your sole point of focus, because when you had decided to purchase or invest, you did so taking into consideration multiple factors. You had done so during happier times, and we keep telling our clients that the happier times will come back again. So eventually, when you are in happier times, you better not take your decision based on only COVID-19 and walk out of a deal purely because of this pandemic. Kindly assess all the factors before taking that call. In fact, as we speak, we just got a call sometime back from one of our clients. It's a major player in the healthcare sector in Calcutta, and we were advising them on a business transfer. They, in fact, even signed the documents for the transfer, but before they could close the transaction, the lockdown started. And today they've come back, they intend to extend the long stop date for the transaction. So they haven't actually given up on the transaction, which is a positive sign, because I think somewhere people have that hope that, things will improve and eventually there'll be happier times again. An important part of any acquisition or investment transaction is the site visit. Now, site visits, of course, now would be next to impossible. So it's important that people realize that site visits may have to be done as a condition precedent to closure, or depending on the integrity and importance of the site visit, even after the closure. What we have also seen clients assess whether any drop in the financial position is interim or caused only due to the outbreak, or is it because of a larger systemic issue or some chinks in the armor that has gotten exposed because of the current situation? Customers and suppliers, you should mind them, and they continue to remain a very critical cog in the apparatus. If there has been an interruption, assess the short-term, mid-term, and the long-term impact. Whether these have manifested into any legal issues, are there any payments due, any claims made that are outstanding? While my partner Suhana will be speaking on force majeure in detail, do remember that there will be life after COVID, and therefore it is important to understand how robust the business will be once the outbreak finishes. If there's any production disruption, please assess whether it is a capacity issue or whether it is an interim one. Because in certain industries, there are reporting obligations depending on the level of production. There could be export import related tax obligations, and all of them need to be considered when looking at the impact of this outbreak. Insurance is clearly something one cannot emphasize enough, and whether there's adequate coverage or not for the ongoing business needs to be assessed. All of this diligence will flip into how you structure your transaction, which we will discuss in the next slide. Next slide, please. In terms of the ongoing transactions, we have been approached by a lot of clients to advise them on the material adverse effect or the material adverse change clauses in their existing contracts. People are going back to their existing contracts to review clauses because they're unable to meet deadlines, and they're coming to us for advice, how to go ahead and what exactly, whether there are events of default and so on. Our consistent advice to our clients has been that do look into the clause, but try and resist the temptation to touch the price or any of the other commercial terms. See, Indian businesses are primarily promoter driven, and any such attempt to alter the commercial terms may be seen in bad faith and may affect the overall transaction relationship. Diligence would have to be done for additional condition precedents. For example, whether there are supplier claims or customer claims, and the warranties and disclosures need to be looked into closely. Most insurers have clarified that they will exclude any sort of loss attributable to this pandemic. Even the warranty and indemnity insurance market is very quickly adapting to the current requirements. Many sellers have inquired about buyer delinquency, again relating to the material adverse change, material adverse effect clauses. Traditionally, India has been a market which rarely sees escrows, guarantees, and payment backed instruments unless there's a specific deal related factual issue. Next slide, please. Thank you. Now, while we are all working from home, it is definitely not business as usual for most of us. As I was discussing, the genuine problems that we are facing when it comes to transactional work, there's a significant amount of physical interface and availability that is required to close a transaction in India. Just for example, when it comes to payments, India has a significant number of exchange control regulations, and a lot of paperwork is needed, and a lot of coordination and hand holding is required with the bankers in place. This requires physical documentation, physical presence, original signature verification, at times withholding tax compliances. All these are taking longer than what they would otherwise take for people working remotely. If you're looking at the requirement of obtaining a director identification number for your director nominees, physical signatures, notarization, legalization requirements, all of these, whether in India or abroad, are being hit by the current business disruption. Any purchase consideration determination or audit adjustments, wherever there is a requirement of additional paperwork, the finance teams are grappling and struggling to a certain extent. Government approvals, a very significant step in the closure of transactions. This is one space where we are advising very cautiously because the government departments have different priorities at this juncture. A transactional approach approval would definitely not be at the forefront of their agenda. As a result, parties to a transaction must plan out appropriate long stop dates. As I mentioned, one of our clients has come back, to draft an extension letter where they intend to extend the long stop date. The long stop date should be extended in such a manner which neither makes the valuation stale nor do they make a close timeline unrealistic. A post-merger integration planning process, which otherwise sometimes may have commenced prior to closure, clearly is something people may not have the bandwidth for, at least on a counterparty basis before closure. Now, this gives a brief outlook of what we are seeing in ongoing transactions. Over to Chandradeep.
Thank you. Thank you so much, Arundam. And what we're going to do is I'm going to introduce the next speaker, because there is a certain amount of connection and overlap between the two presentations, and the questions will come together for both Arundam and Suhana. So I'm going to go ahead and introduce Suhana now. So Suhana is again a partner in the corporate and commercial practice group of Khaitan and Company. Her core expertise includes private equity investments, mergers and acquisitions, business transfers, JVs, foreign investments. She advises several MNCs for the Indian strategies, inbound investments, and foreign exchange laws. Her work experience is in M&A, private equity, and has spanned several sectors like FMCG, retail, manufacturing, IT, and ITES. She's also involved in the firm's startup initiative and actively engages with startups through various forums. She's been recognized as a notable practitioner in the IFLR 1000 2020 rankings. And what she's going to talk about is about how do companies deal with changing market scenarios, massive supply chain disruption, and how to meet ongoing contractual obligations, and specifically what could be the legal excuses of the performance or non-performance of contracts, and the term that we hear these days a lot, which is force majeure. I hope I pronounced it right. So she's going to talk about that, and doctrine of frustration and material adverse change clauses. So these are things that Suhana is going to talk about. And after that, we're going to throw the floor open for questions for both Arundam and Suhana. Okay, with those words, I'm requesting, I can see Suhana, and I hope her voice has been unmuted.
Yes.
Great. So Suhana, over to you. And thanks for being with us.
Thank you, Chandradeep. Thank you for that introduction. But before I start, I feel my bandwidth is as bad or good as the stock markets these days. So I'm going to switch off my video just for the purpose of this short presentation that I have. And then I'll come back on again if that's all right.
Yeah, sure. Go ahead.
And in case I'm not audible or the PPT is not seen at any point, please let me know.
No, as of now, it's fine. Go ahead.
Great. Okay, so thank you everyone for joining in. We are at the fag end of this webinar, so thank you for staying on. As Chandradeep mentioned, I'm going to talk about certain contractual excuses, legal excuses, so as to speak, from contractual obligations. Now, the contractual landscape nowadays is changing, and how we live in exceptional times, as we all know by now. And I'll tell you a short story before I start. And this was told to me by a senior advocate, actually, so I don't take any credit for it. So, there is a husband and wife, and the husband is not getting any sleep at night. And the wife asks him, what is the issue? Why are you getting sleepless nights? And he says, I have to pay 5,000 rupees to my neighbor tomorrow. I don't have the money. So the ever dutiful wife that she is, she goes to the neighbor and she says, my husband needs to pay you tomorrow, but he's not going to. And she comes back to the husband and says, look, you can go to sleep because the neighbor is having sleepless nights now. So that really, on a lighter note, is where we are. I mean, as you mentioned, with a supply chain, the disruption, with all these challenging business issues that we are facing, it's very difficult for businesses to actually keep up to their contractual obligations. So whether it's provision of services, supply of goods, whether it's paying your rent to your landlord, these are all really important considerations, and we know that because force majeure is now the buzzword really. Now, what is force majeure? So I'm going to deal with legal excuses in three aspects. One is force majeure, which is the most commonly used phrase that we are seeing nowadays, followed by the doctrine of frustration and material adverse change, because all of these together can be clubbed as a category of legal excuse, where if it allows a party to a contract to actually either suspend your obligation for a certain period of time, in some cases even exit your obligations. So force majeure can typically be found in commercial contracts. So whether it's your supply, your rent agreements, like I mentioned, even license agreements, construction, manufacturing, wherever there is some dependence on a third party for procurement of raw materials, these are typical contracts where you will have this clause. Now, this clause is very important in order for, and many of you may have either wanted to invoke force majeure, or you may have received a force majeure from your, say, tenants or from your clients. Now, it's very important to understand, to take the benefit of this force majeure clause, one must have this clause in the contract to begin with. It's a contractual right. So it's not really a statutory right, it is something that stems out of your contract. Having said that, there is some basis under law, of course. We have a plethora of judgments on what force majeure is and is not, but it is also provided on some reference can be drawn from the Indian Contract Act and Section 32 in particular. Now, Section 32, I don't want to get too technical about it, but basically it says that if there is a contingent contract, like a contract to do or not to do something, which is dependent on a future unforeseen event, then until and unless that future unforeseen event happens, I cannot really enforce it. So what are the typical ingredients of a force majeure clause? Now, like I mentioned, it will have a list of future unforeseen events. So typically you would see that you have these acts of God, as we commonly refer to, which are used to denote very loosely to these natural forces of destruction. So you have hurricane, you have flood, earthquake. After the tsunami, people started putting tsunami. Flood, after the Mumbai floods, people started revisiting the force majeure clauses and started putting all this. And now I'm sure everyone's going to relook at their clauses and start putting lockdown and epidemic and pandemic in it. But you will have a list of events followed by a list of consequences of those events. So typically a force majeure clause is going to tell you that, look, if these events happen, then usually there is a suspension of your performance obligation. So for that period of time, without any liability, parties can suspend whatever performance they had to do, whatever they had to do under that contract. And sometimes it also allows for termination. So if it goes on for too long, you can terminate the contract. So it will really depend on how your clause is worded. Sometimes the clause will have some exclusions, like some things which you cannot suspend. Like even if there is a force majeure event, you would have to continue to do those obligations. And there will usually be a mitigation and a notice requirement, which I'll come to in a bit. Now, whether COVID-19 is a force majeure event, whether you can classify and therefore suspend your obligations, or if someone is asking you, can you give him that benefit, is a question that's on everyone's mind. But unfortunately, this is something that we'll have to, it's not very straightforward to answer. It is going to depend largely on a case-to-case basis, and it will depend on your entire contract, your governing law, and most importantly, your clause itself. So in front of you, you can see 3 examples of force majeure clauses, which are typically found. I've culled them out from existing agreements that we have. Now, if you see the first clause, and I'm just going to read out because this is relevant. It says force majeure means any event, including, and it lists out act of God or any other event which is beyond your reasonable control. Now, if you see, this is a very wide general clause. So if you have a clause like this, because it actually says it's any event, and then it goes on to say including. So it's an inclusive definition. There may be a good chance to actually argue that yes, COVID-19 does fit in. So you will see the words pandemic, epidemic, are not really mentioned. Having said that, because it's so wide, there may be a good chance to classify it as a force majeure event. So again, it would depend on how your clause is worded. Your second example that you can see in front of you is a more, it's also an inclusive definition, but it is more restricted in the manner that it says that force majeure means and includes, and then it lists out a list of events, lightning, earthquake, etc., and all other events beyond your reasonable control. Now, the fact that it says in the underlined portion, and any events should not be construed to mean any event under the earth and therefore under the sun, and then therefore, classification of COVID-19 should not be the automatic conclusion. And the reason is there is a very widely known and very there's a wide rule of interpretation uniformly applicable to clauses of such nature, which is called ejusdem generis. And all that it means in simple terms is that if you have a catch-all clause like this, all other events, and this catch-all clause follows your specific events, then it will be very narrowly interpreted. It'll have a strict interpretation. It's going to be interpreted only limited to the events that precede it. So in all likelihood, all other events here would also mean only acts of God like lightning, earthquake, etc., etc. And the third bucket you have is there's really no room for interpretation. It's simple. It says force majeure means X, Y, Z. So whether or not COVID-19 pandemic is mentioned, then great for you. If it isn't, then you will have to then see whether you can classify it as, I don't know, a natural disaster, an act of God. Now, there is jurisprudence to say that acts of God, natural disasters are usually construed to mean natural forces of destruction which are outside our control, and COVID-19 is really not as such a natural disaster. So, I mean, that is a moot question and it has to be legally evaluated. So just a few, theme points here. First of all, to invoke force majeure, you need a contract which has that clause. If the answer here is yes, then you should check the next point, which is, does it have these tell-all words, pandemic, epidemic, government action, order? If the answer is yes, then you move on and say that, and you examine whether this event, the force majeure COVID-19, is directly prohibiting or preventing you from doing your obligation under that contract. See, just commercial hardship is not enough. It's not enough to say that, okay, I have rented your place, I'm using it, I'm coming, 50% of my workforce is coming, but I want force majeure. Question is it really impossible for you? And how difficult is it for you to perform your obligation? And is there a likelihood of mitigation? So even if your clause really doesn't have a mitigation aspect, if it does not require you to mitigate, there is an implied, and there is case laws on this to say there is an implied requirement of mitigation. So if you can mitigate the hardship, you can mitigate the force majeure event, chances are that courts are not going to uphold a force majeure invocation. See, just to put it in context, I'm also talking about a worst case scenario. I'm talking of a scenario where one invokes a force majeure and the other contests it, and you have to defend it in a court of law. What we are advising clients is, now, if you can, please do resolve your issues amicably. Try and have a reasonable and just approach. So if it is decided, in a consensual manner, then nothing like it. This is all when it, actually goes down and it has to go to a court of law. So then these are the aspects that you have to keep in mind. So just to sum it up, key points on force majeure. Like I mentioned, strategize your goal. So we've had clients who've said that, X and Y is my key client. They are like 90% of my revenue. And now he's invoked a force majeure. What should I do? So the answer is that you have to strategize. What do you want? Do you want to lose your key client? Do you want to suspend obligations? Do you want them to walk out? So you will have to also strategize your approach accordingly. Also one more practical tip I can give you is that if you have or you want to invoke force majeure, you really don't have a clause in your agreement, then it may make sense to just put in an email without saying I'm invoking force majeure and without getting really technical about it. Just try and say that, this is the hardship I face. Document everything. This is the hardship, this is the impossibility I'm facing. Please grant me suspension or whatever you want to seek. The rest I've already dealt with. You have to establish a clear nexus between the event and the default or whatever you're not able to do. Ensure compliance with all formalities that are there in the clause. Like I mentioned, your clause will have a typical notice clause, which will set out how you have to give notice. It may, and most likely, it will have some mitigation clauses also, aspects also, which will say that, try and mitigate for say X number of days, and only then you can invoke force majeure. If that's the case, please follow it to the T, because tomorrow if you have to go to a court of law to defend it, you must have followed your contract to the fullest. And document everything. Like I mentioned, it's very important to have a good defense and to document every communication that you're having. So with that, I want to quickly move on, because we do want to take more question and answers at the end, to the next concept of legal excuse. Now, what happens, I mentioned force majeure is a contractual right. It has to stem out of your contract. Now, what happens if you don't have a clause in your contract? Are you without any sort of legal excuse to perform? The answer is no. You can still claim, as we commonly know, something called the doctrine of frustration. Now, unlike a contractual right of force majeure, this is a statutory right. It flows from law. It flows from your Indian Contract Act and Section 56 in particular. Now, what does Section 56 say? It says that, look, if you and I enter into a contract, and after we enter into that contract, for some reason the contract becomes impossible or even unlawful, then that contract becomes void. So the key difference between force majeure and frustration, it's important to understand. Frustration absolves the parties completely, it discharges all obligations, it becomes void. As opposed to force majeure, where the contract can be subsisting, it can continue and be valid. There's a temporary sort of suspension of your obligation. Here, the contract is completely void. There's really no going back to it. So, word of caution, be very careful when you're invoking doctrine of frustration or trying to fall or classify COVID-19 as, as a doctrine of frustration, and that your contract is completely frustrated. Now, again, whether COVID-19 will amount to an event which will give rise to a doctrine of frustration itself is not a very straightforward answer. Now, there are hundreds of years of jurisprudence backing what is doctrine of frustration. In front of you, I have laid out 5 key tests that a court is going to look into. And I'll just explain this with the help of a small example. It is a landmark judgment which was given in 2017 by the Supreme Court of Energy Watchdog. Now, here you had Adani Enterprise as one of the conglomerates, and they had entered into a power purchase agreement with the state electricity commissions. Now, as its procurement of raw material was required, Adani had a separate agreement with this coal supplier in Indonesia, where it to procure the raw material for this power purchase agreement. Now, something happened. The law changed in Indonesia, and the price of coal quadrupled. It just became very expensive. So Adani went to the Supreme Court first and said, and of course I'm simplifying the case here, and said that they invoked force majeure. Now that could not be upheld for various reasons. The clause did not allow it. So then they said, this is doctrine of frustration. It is impossible for us to perform this contract. We want to, walk out of it. It's impossible. So these are the 5 things the court kept in mind then. Is there a fundamental change? See, again, just the fact that now coal prices has become expensive and it's more dearer, and that's not enough. Commercial unprofitability, hardship, it does not mean impossibility. Impossibility would mean that it doesn't have to be practically impossible or literally impossible. It has to be just so, it has to strike at the root of the contract. It has to be so impracticable and useless to the purpose and object of the contract that it's just not possible to perform it. So it has to be like a fundamental change. Again, if you have alternate means of performing your obligation. So in this case, the court said that if you cannot get coal from Indonesia, you can get it from elsewhere. So, if you can show that there's an alternate means of you to perform your obligation, the court will possibly not say that the contract is frustrated. Again, duration is important. Now, COVID-19, we are not sure some people are saying it can be viewed as a temporary situation as opposed to a permanent situation or semi-permanent, because obviously there should be some timeline to it. So the longer the duration of COVID-19, the possibility of saying there is a frustration is easier, but that will have to be tested when, as time goes on. So we've dealt with it. Basically, to sum up doctrine of frustration, it is a statutory right. You have to show impossibility, and it's a very high standard. So compared to force majeure, it's a very high standard and bar that has been set by our case laws and jurisprudence. Now, if someone does invoke a doctrine of frustration and say that it's impossible, and if you do contest it in a court of law, it's not that you are without remedy. There are certain remedies for the non-performing party. I'll be happy to take on questions on that if it's relevant to the audience later. And I'll quickly move on to the last aspect of legal excuse, which is your material adverse change clause. Now, my partner Arindam already dealt with it briefly. And I just want to say that the most material adverse change is, I feel, would be used to some degree now, given that, as an M&A lawyer, we can sense that deals are slowing down. People are very cautious. So while Reliance Facebook happened this week and it was possibly the best news for corporate India, there are other deals which are not happening. In the US, there are two huge deals. I think one was an $8.5 billion deal, Gray Television's acquisition of Tegna, which is a broadcaster, Xerox's hostile takeover of HP. These actually people pulled out and they cited COVID-19 as a reason. So MAC can be used in the coming future. It's commonly found, this is a clause which is found in your M&A deals, like I mentioned, and also in your loan documentation. So people who have taken loans would commonly find it there. Now, what is a MAC really? So MAC is nothing but it's a clause which will occur in one of these agreements. And it says that if any event causes a material adverse change, and then it will be linked to many metrics. So material adverse change, say in your financials, in your operations, in your liabilities, in your EBITDA, in your earnings, and there could be specified metrics or assets. So it's a highly negotiated clause, and much would depend on how the clause is going to be worded, but usually it is going to be linked to certain metrics. And what we are seeing is that investors or buyers can use it, or even lenders, to get an exit, because the consequences of MAC is that it does allow an exit completely of the investor or the buyer, because it's essentially a risk allocation clause. Sometimes if they don't want to exit, they want a price adjustment, or they want some indemnity, escrow structure, or sometimes they can have a deferred consideration mechanism. So there are certain alternate mechanisms also that can take place. Now, MAC will usually occur in several ways in an agreement. Usually it could be a condition precedent to closing, which can say that no MAC has occurred since I signed this agreement up to closing. It could be an event of default. So even after you have signed an agreement, the investor can say that a MAC has occurred and therefore we want XYZ consequences. So it could occur in a variety of ways. So again, whether COVID-19 will allow a party to walk out of a M&A or a lending arrangement would depend on how MAC is used, what are the metrics that are mentioned in the clause. And usually a MAC would also have certain exclusions. So like I mentioned, it is a very highly negotiated clause. A good negotiated clause, if it is seller friendly or a target friendly clause, will have exclusions. Typically, it has become customary now almost to have exclusions, for example, market conditions, economic conditions. So if your adverse change in your company financial results is happening because of, say, market conditions or change in law or act of God, most typically, these are excluded, but it would depend from clause to clause. If it is excluded, then you are in a better position and you can say that no, MAC is clearly, a person cannot walk out because of MAC. Now, again, enforcement and establishment of a MAC in India is not very tested. So unlike a doctrine of frustration, we don't have a lot of jurisprudence on MAC. But we can look towards the West. We can look at the US, which has a plethora of judgments on MAC, and these will have some persuasive value if it is being contested in India. Now, the bar is typically set high for a MAC clause also. So if someone invokes a MAC clause and wants to walk out and you want to contest it, at least going by the US case laws, the bar is high. The courts in the US have laid out a few tests, some of them which I'm going to deal with. For example, the impact of the MAC has to be long term. So a short term hiccup in the next few or the next quarter's financial result may not be enough. You have to show that long term damage has been done really to your company and its business. Prior knowledge of events. So if you're entering into some kind of an M&A deal now, and you are entering into it in the midst of COVID, now to take benefit of this at a later stage and say that there is a MAC may be difficult. Again, the impact on your business has to be disproportionate. So for example, if you're a restaurant, then you have to show how MAC has disproportionately affected your restaurant as opposed to the food and beverage industry in general. So again, it's a high standard. And I'm saying this from a seller target friendly manner, that the way forward here would be to have as many carve-outs as possible. If you are in the midst of negotiating a MAC clause, if you are negotiating a deal, entering into an M&A transaction, have as many carve-outs, exclude forward-looking references. So any reference to your prospect that I'm going to have X, Y, financial results in the future, try and exclude all that to have a better position. And finally, very quickly, I'm just going to spend a minute on this slide, which is my last slide. And this is basically for all the founders or for the startups in the audience today who may want to or have already begun the process of fundraising, or you have signed a term sheet, or you would like to do that in the future, you anticipate that. Key points to keep in mind. If you have a term sheet, please open it. Please see your exclusivity. It's a very basic point, but people are missing out in it. See your exclusivity period, see your tenure. If you need to extend it, please do so first and foremost. Secondly, very important, keep having a dialogue with your investors. Make sure they're aware of what's happening. Honest, open communication. So Pratim had mentioned over communication is good now. So over communicate if you have to. If you are in the midst of negotiating any investment agreement, and if you have warranties and representations you're giving about your business, ensure that you have carve-outs. It'll be great if you can completely carve out this COVID situation and the negative impact of it, but I'm not sure if that will fly. If that doesn't, then make sure that you have not lot of qualifiers, knowledge qualifiers, materiality qualifiers, to sort of limit your liability or to reduce the extent of your liability. Have disclosures. Like I mentioned, most reps and warranties will require you to have disclosures. Make your disclosures specific and wide so that you have better protection. Close attention to standstill clauses. What are these clauses? These are clauses which will say how you should operate business between signing of a deal and closing. They usually require prior investor consent, so make sure you get those. Arindam already mentioned, if you need to extend your long stop dates, do so. MAC clause, again, negotiate your MAC clause, make sure it's reasonable, you have exclusions. And just be open to revisiting your term sheet, your commercials. Investors are asking for price adjustments, they are re-looking at valuation. So have an open mind, see what are the alternate ways and means to achieve the end goal. And yeah, finally manage expectations. So that's it from me, Chandradeep. Over to you, and we are happy to take on questions at this stage.
Okay, thank you, Suhana. I think one thing I must say, and I really appreciate for all three of you, I honestly get a little scared talking to legal people because you guys use a lot of legalese, and I think all three of you have been exceptionally clear, simple English, real life situation. So I think, I mean, even somebody like me, in fact, I was joking with all three of you at the beginning, saying I don't know why I was chosen as the moderator. Maybe because they needed somebody who's the least legally qualified person to be the moderator, to represent the, you know, parts of the audience who don't know much about law. But having said that, I think what you guys did today was almost entirely understandable and pretty clear given the limitations of time and technology. So firstly, thanks for that. And I do have a couple of questions, but before that, you know, maybe I'll do it while wrapping up, and maybe I won't need to ask those questions because the questions may naturally come up. So we have maybe about 10 or 15 minutes max, because it's been a long session. Thank you so much, and very informative. But I'm opening up the floor for questions, right? So anyone has, and I think there's a lot of connection or some amount of overlap between what Arindam and Suhana did. So so whoever asks the questions, just identify yourself, and in case you want the question to be answered by one person in particular, mention who it is. Otherwise, between Suhana and Arindam, they can choose who want to answer the question. So go ahead.
Yeah, I've unmuted all the participants. Participants, please ask your question if you have any. Please raise your hand. Yeah. So Mr. Dilip Singh Mehta has some questions to ask. Please go ahead.
Hi, Suhana. It was a very nice delivery. Congratulations for that. Am I audible? Hello? Can you hear me?
Yes,
Yeah,
I can hear you.
Okay.
Thank you.
So my question was that the way things are going, there's fair amount of fluidity in the situation, and irrespective of whatever are the laws and whatever are the facts and factums behind force majeure or doctrine of frustration, what do you really think would be the way forward to close unnecessary litigation? Because it's obvious that everybody would like to find a way out, including a bank who's one of our tenants wants to sort of remit not pay the rent for the month, whereas they are doing great business. They are earning interest without having to do anything. So how does one get around unnecessary litigation in this fluid situation?
So thank you, Mr. Mehta. It's a great question and very relevant. I think what we've been telling clients really is to have a very reasonable approach. I mean, it is tough, but in the example that you gave, I mean, if it's an essential service, then the reasonableness will also have to be examined accordingly. So, but the best way to avoid unnecessary litigation and too much of litigation that we may be heading into is to have a reasonable approach. First of all, if anybody is invoking force majeure, please be cautious about it. Just don't invoke, because it gives you some kind of commercial slight benefit. But if it's not really a hardship, I don't think there is any necessity to really invoke it. Secondly, it's the best to have an open communication and see if that the matters can be amicably resolved, and that's the case we always say to all our clients. Try and see if if you can give a waiver of a month and two, like a moratorium, like say the banks are giving for term loans. Give a moratorium and have them pay after the COVID-19 lockdown sort of gets over, but not like forego it altogether. So just come to a middle ground where both parties are happy and it's done in a just and equitable manner. So that would be my takeaway.
Thank you, sir.
Thank you.
I have another question from Mr. Sutesh Kedia. Yeah, hi Sutesh. I guess he has muted himself.
Oh, hello.
Yeah, hi
Hello.
Sutesh.
Yeah, hi. Suhana madam,
So,
like the thing,
yeah.
yeah. Am I audible?
Yes,
Yes,
you are.
yes.
Yeah. Ma'am, I was asking, like, I have a tenant who's like he's a quite well-known MNC, and but they are forcing us to go for a 25% rent cut. So what would you advise for us to do? Because we don't want to lose the client also, because it's a very big client. Obviously I cannot disclose the name, but it's a very big client and it's an international client. But they pay their rents very well. They are a very good customer to us. So, ma'am, in that case, what would you advise us to do?
So in that case, sorry, I didn't get your name.
And my name is Sutesh, ma'am. Sutesh Kedia.
Sudesh. Sure.
Yeah.
So Mr. Kedia, in
Yeah.
that case, see, it's not really a legal answer I can give you here. You already, I think I've gone through the legalities of it
Yeah.
all.
Yeah.
But like I
Yeah.
mentioned, it's important to strategize. So if this is an
Okay.
important client for you, see what you're
Yeah.
earning from this client, how, and you want to retain it. So my advice would be have a long-term view, and
Okay.
25% or 15%, 30%, that can always be negotiated.
Okay.
But if you think it's important to hold on to the client, your end strategy should be that.
Yeah.
So,
Okay.
yeah.
Ma'am, that's what I've just listening to you. Like you being a senior, very senior lawyer in a very renowned company, that you know right now it's better to settle and move ahead instead of going into any legal disputes. That's what your major advice is right now.
Yes, and that's our advice even pre-COVID, Mr. Kedia, because we always say if you can settle it, it's better than it languishing in the courts for 2-3 years or even more.
Okay, ma'am.
So
Thank.
it's always better. And you also do a
And
cost analysis,
yeah.
because if it does get into litigation, the cost there versus the 25% discount here. So do that
Yeah.
exercise as well.
Yeah, because we normally people forget to take the legal aspect, the legal cost into action. Thank you, ma'am. Thank you so much.
Okay,
So
are
any
there
other
any more
questions?
questions?
Yeah. Any other
Okay, so
question from the attendees? Please raise your hand.
while we wait for any other questions, may I throw in a couple, Arindam and Suhana?
Sure, please go ahead.
Okay, so one thing is, delayed payments and not having a visibility of when the payment's going to come in. And if, your clients keep saying, let's get money in, we are in a working capital crunch, wait and see. And if it's like you have to keep providing service month on month. So what is the way, how do you handle that? I mean, you understand that everybody has working capital crunch. I mean, maybe you do, so does your client, and the client's delaying payment, and that gets inordinately long. And then what do you do? How do you handle that from a legal point of view and a practical point of view?
So I'll take this one, Arindam.
Yeah, yeah.
Basically, I see, again, I don't think there's a legal answer here. It's more practical. How do you handle it? You will have to do, like I mentioned, a cost analysis. You have to see who's the party invoking it. What is your end goal with that? Sometimes it's better to let that party just go and walk out, as opposed to have them stay on without paying rent. So it would really depend on what is your strategy for that business, for that client, in that particular sector, keeping in mind whether it's an essential service or not, and the actual factual situation of your client. So if or the person who's supposed to pay up and is not paying. So if actually they are doing very well and they are in a position to pay, then I think the stance can be a little more rigid as otherwise. That would be my take.
Okay.
And
The other question. Yeah, sorry, go ahead,
Dominic,
Arindam.
sorry. Yeah. Are you also trying to ask us like how we deal with our clients when it comes to payments and
No,
all?
no, no,
Is
no,
that
no,
what you
no. That
trying to?
is your
Okay.
strategy. I won't dare to
Right.
ask about
Right.
your strategy. Okay. The next thing, this is just for my understanding and maybe some others too, is you said, in force majeure, there are different definitions, this whole act of God. So what I understood is that it's still not very clear whether COVID can or cannot, or a pandemic can or cannot be called an act of God. Am I right?
That's right. So the understanding with act of God so far, and obviously COVID-19 has not yet been tested in a court of law. So force majeure and what it includes today has not been tested. So going by past jurisprudence on this, act of God is usually considered to be something which is a natural disaster. And to my mind, COVID-19 is not technically a natural disaster. Of course, that is why we are in a lockdown as well. So yeah, it is difficult to classify it as an act of God. It would depend whether COVID-19 can be considered force majeure would depend on how widely worded your clause is or how narrowly worded it is. So it would have to be examined on a case-to-case basis.
Okay, and the other thing was about the doctrine of frustration is also applicable when it's permanent. When it's a temporary thing, you cannot. Where COVID, as of now, maybe seem like a temporary thing. Therefore, that again would be difficult to apply. Is that correct?
That is correct, but it cannot be just one test. So the duration or whether it's temporary or permanent cannot be the only factor in understanding or deciding whether it'll be frustrated or can the doctrine of frustration apply. It has to be looked as a whole in a cohesive manner, and all tests should be applied. So one of the factors that the previous Supreme Court judges and cases have held that if it is permanent or semi-permanent nature, it is easier to sort of argue and say impossibility of performance as opposed to a temporary. But you will have to consider all factors together.
Okay, so connected to with all of this, I mean, we understand that there hasn't been enough legal precedent, but are you aware in India or outside any kind of legal situation arising or any case which has already been filed connected with COVID? Has that happened yet or no? No, people are still waiting and watching.
No, so there are quite a few cases filed in the Delhi and Bombay High Court, but these are all for ad interim reliefs. So usually these cases are for NPA classification, and they've said for pledge invocation. There is one case where there was a supplier who had dispatched goods from South Korea, came to Bombay, and the buyer here said, I cannot buy because of COVID-19. In that case, the court, it was the Bombay High Court, I think it was 8th April, 10th April, so just this month, and they said that no, you'll have to pay because the factual situation here has to be considered, because the court said that look, the contract was on the delivery term was such that the risk in the good actually passes before it is physically delivered to the buyer. And he said that also the force majeure clause in this particular contract was only for the seller and not the buyer, so the buyer could not claim benefit of it. So there have been differing views, but they're all for ad interim relief. And the court really hasn't gone into examining whether COVID-19 can constitute force majeure or not. They're just giving interim reliefs for this duration in exceptional circumstances.
Okay, so connected with this, if anybody gets into any legal contract, whether you're a buyer or a seller, knowing that COVID has happened, knowing that now pandemics are becoming more and more common. I mean, nothing has been as far-reaching as COVID, but we've had SARS, we've had MERS, and some people saying COVID could come back again after a year or two with a mutation, God knows what. So any new contract that you get into, how do you protect yourself? I mean, you're saying you don't know whether force majeure will apply. You don't know whether frustration will apply. So what is the only legal way of protecting yourself while getting into new legal contracts from now on?
So to my mind, if you are entering into a contract now, and if in that contract you're dependent on a third party to do or not do something, or if you are expecting an obligation to be performed by the other party, then you must have a force majeure clause. Make sure that if you are the non-performing party, if you are the party that is receiving the service or the goods or whatever it is, then ensure that your force majeure is wide enough to include any future eventualities. Of course, pandemic has to be and lockdown and governmental order, governmental regulation should be an aspect of it. but generally have it as wide as possible so that you can take benefit of it going forward.
You can mention words like pandemic, lockdown,
Yes,
whatever.
yes.
Those are things in
Yeah.
the contract can now be mentioned and probably should be.
Like I mentioned, after the tsunami happened, everyone started putting tsunamis in their force majeure clause. So you can definitely include pandemic, governmental lockdown, just in a bill. Yeah, words like that too in your clause.
Okay, great. Okay, Neha, are there any questions? Any other? Hi, Neha, you're there?
Chandradeep, hello.
And there,
Yeah.
Chandradeep, hi. This is Arindam here.
Yeah, go ahead.
Yeah. See, on the litigation front, other than the ones which Suhana mentioned, I just came across a writ petition also in the Supreme Court against some of the government orders. The mindset of the employers now, it's also coming out because the writ petition has, the government has come up with an order where they've mentioned that, you should pay full salary to the staff and workers, contract workers, etc., etc. Now, there's a writ petition filed against such government orders because the employers, some of them believe that, we are not earning. So how do you expect us to make payments?
I'm glad you mentioned this because in an earlier session, TiE session, some of our some of our other members were talking. See, depends of course on the business you're in, but typically in most businesses, two of the largest cost components would be salaries and rents, right? And if you're not earning and you're having to pay out salaries, and there's a government order asking you to pay salaries, including the fact that government is saying it's a lockdown, no one can work, or only 50% people will work, or whatever, and you have to keep that'll affect production, and yet you're supposed to pay salaries to everyone. So, what is going to be the way forward? How are companies and business owners going to be able to handle this situation legally? Financially, we leave it aside. Legally, what is the way out? Hello? Yeah. Hi. Arindam and Suhana, are you going to respond to that?
Yeah. Can you hear me?
Yeah.
Yeah, I think it's more of a wait and watch thing because I think one of the ways is to file a writ against the government order. But in fact, a lot of clients have come back, saying what can be done under such circumstances because people are thinking of laying off people. People are thinking of reduction of salaries. Uh, so I think depending on from a case to case basis, because contract workers again are not your employees. So as far as the contract workers are concerned, I think there's still a possibility of going ahead and not making the payments. Uh, but I think it also depends on how workman is defined. While it's not my area of law, but then I think we need to analyze the labor and employment laws and then take a call on that.
Okay. So in effect, we are in gray zone on this one.
That's right.
Okay. Neha, are there any other questions?
Yes,
Sorry,
yes. We have
you
a
wanted to say
question
something.
from Mr. Anand Sureka. Yeah, hi, Mr. Anand Sureka.
Yeah, hi. My question is pertaining to the previous one, in continuation to the previous one. We are manufacturers and we have both contract employees and permanent employees. So in case of our contractual employees, we have got permission for certain number of workers to come in. And now we are in a even bigger dilemma wherein we might have to follow government orders and have to pay workers who are not coming. So what about the workers who are coming? They will find it unfair and they will even stop coming. That see, there are people who are getting money paid for not coming. So why should they come? So it's a complete dilemma in which we are, and we really do not know how to deal with this. Hello.
Yeah, Arindam, Suhana, do
Hello.
you want to respond?
Again, as I mentioned, this is not my area of law, but sir, if we can obviously take your question offline and I can connect you to the right person, my partner who deals with employment, to analyze this particular question, if it's fine, because it
Okay.
could involve, evaluating all the labor laws. Yeah.
Okay, so this becomes a labor law issue which needs deeper delving, and it's a bit of an uncharted territory, is what I'm understanding. Okay, are there any other questions? I know we are over 7 o'clock. We've had a really interesting, enlightening session. So unless there are any other questions coming in the next 30 seconds, I think.
No, I am unable to see any other questions.
Okay.
Your participants requesting, if you have any questions, please raise your hand.
Yeah, we are going to wait 30 more seconds and maybe have time for maximum one more question. But if not, then I'm going to request Arindam and Suhana, in case they have any concluding thoughts, to just share it verbally. And then I'm going to do on behalf of TiE, I'm going to do the thanking and closing the session. So
I
are there
guess we
questions
don't have
coming up?
any further questions. No.
So
No,
Chandradeep just wanted to mention our email addresses are on the screen. So if anybody wants to get in touch offline, we'll be happy to have an offline chat as well.
Great. And anyway, we have our all your email IDs with us, Neha. So
yeah, I'm going to share it with all the attendees.
You can also share it with the TiE community, because I think given the time and knowledge that you've shared, there could well be follow-up questions and thoughts, because the whole situation is emerging and evolving. So we'd be happy
And
to.
I think one Mr. Kedia's question went unanswered. So if he could write to us on our respective IDs, then we can get back to him.
Sure. Good. So before I give my final thanks, Arindam, Suhana, any other last final thoughts from either of you or both of you?
Should I go first, Arindam?
Yeah, please.
So just wanted to thank you, Chandradeep, for this excellent session and leading us through it. And thank you, Neha, and everyone at TiE. I've actually been a TiE member since the beginning of my career. So it's always good to be associated. And yes, thank you. And I hope it was beneficial, and we are available if you need to get in touch with us.
Likewise.
Thank you, Suhana. Arindam, anything else?
No, that's it. Thank you.
Okay. So on behalf of TiE Kolkata, I want to thank all of you, Arindam, Shupratim, and Suhana, for the wonderful session. This has been one of the longer sessions. It's lasted for more than 2 hours, and it's really been packed with information, valuable, actionable insights. And it's about a very serious, important, and even contentious set of issues, which is all the legal things. So I think it's very valuable to know what you guys shared, and hopefully this will help some of our members, and hopefully if there are further questions or some help, some of us will reach out directly to you. We have your mail IDs. And on a personal note, for really a person who knows so little about law, I was really scared about interacting with 3 senior lawyers like you and partners. So you made it really simple, easy to understand. So I really appreciate that. Even I could understand, I think, most, if not all, of what you guys said. So that's really a credit to you people. And I know we are living in very uncertain times. So knowing to what extent you can be legally protected and what are the ways to protect yourself, and what are the, not just the legal part, but also the sensible, practical ways of handling things, were a lot of good inputs and insights that we got from you. So we really appreciate this. Thank you so much. And maybe as the situation progresses and more things happen, we may need your advice and inputs at some other point of time. Till then, thank you on behalf of TiE, and thank you personally on my behalf. I'd love to stay in touch with all of you. And goodbye. All the best.
Thank you, all of you. Thank you so much for the wonderful session. Thank you.
Thank you.
Bye.
Thank you.